I would like, therefore, to introduce our second paper and the two panelists. The second paper is by Dr. Japhet Biegon and Andrew Songa. Dr. Biegon is a legal and policy expert on the normative and institutional architecture of the African regional human rights system. He has more than 15 years professional experience practically engaging with, writing on, and teaching about the African human rights system. Dr. Biegon is currently the Africa Regional Advocacy Coordinator for Amnesty International, and he leads advocacy before the African Union and its diplomatic representatives, or rather the representatives accredited to the Union. He's an extraordinary lecturer at the Center for Human Rights, University of Pretoria, and he holds an LLD in International Human Rights Law from the University of Pretoria. Andrew Songa is a lawyer and human rights advocate with experience in the areas of legal research, policy formulation and analysis, domestic and international policy advocacy, and civic education. He is currently a consultant on advocacy related to the African Union. He's a member of the advisory panel for the study of transitional justice in Africa by the African Commission, and was also a member of the Commission's reference group that was responsible for drafting the general comment on the right to redress for victims of torture and other ill treatment. He has also served on the advisory panel of the Open Society Justice Initiative's Study on Strategic Litigation Impacts. Mr. Songa is a graduate of the Geneva Academy's Master of Advanced Studies in Transitional Justice, Human Rights, and Rule of Law. They will be speaking to the paper titled A Source of Respite from State Backlash, and this is concerning individual access to the court through the Commission. Dr. Biegon, Mr. Songa, the floor is yours.
Thank you very much, Humphrey, for that introduction. I will be kicking off the presentation of our paper and then handing over to Dr. Biegon to conclude, but very mindful of the time allotted to us, which is the 15 minutes that we will share between the both of us. So I will seek to share my screen for the presentation. And I just want to confirm that my screen can be viewed. Great, excellent. So I will just put it into full screen mode and proceed. So greetings to everyone. Once again, I'm very happy to be part of this very, very timely and great celebration, both of the African Charter, but also of the great lives and works of Professor Christof Heyns. As Humphrey has already introduced, the paper that we wish to discuss relates to the access to the African Court on Human and People's Rights for individuals and non-governmental organizations, and particularly reflecting on the referral process of the Commission as a source of respite from state backlash, as I will now quickly introduce and discuss. So between myself and Dr. Biegon, I will briefly introduce the paper, discuss the vision of the African Court's protocol on enhancing and strengthening the African human rights system versus the shrinking space of access for individuals and NGOs. And then I will hand over to Dr. Biegon to talk about the evolution of the referral framework and our conclusions and reflections as a result. So to quickly begin, I would say that our paper is situated within a backdrop of recent turbulence within the African human rights system. And by that, I refer to some recent decisions within the African Union Executive Council that had called to question the interpretation mandate of the African Commission on the one hand, but then also a trend of states withdrawing their declarations under Article 34.6 of the African Court Protocol, and therefore limiting access for individuals and NGOs to the court. And what we are seeking to interrogate is, within this prevailing climate, what recourse can individuals and NGOs take to maintain access to what should be a very essential avenue for redress and anchor for the African human rights system. So to quickly begin, and also tapping into what we had earlier in the day with the opening remarks, particularly by Dr. Eno, it is good to take stock of the vision that informed the African Court Protocol as we try and reconcile it with the prevailing climate, as I've mentioned, of shrinking space of access. And what was the vision for the protocol? The vision was essentially one that of establishing a continental court that enjoys equally continental support, that can then also strengthen the African human rights system by issuing binding decisions and working in complementarity with the African Commission on Human and People's Rights. Just to quickly refer to a quote in the run-up to the development of the court by Professor Makau Mutua, the essence of the development process was to establish a court that wouldn't necessarily repudiate the African Commission, but acknowledge some of the ineffectiveness that had been experienced by people who had engaged the system, and therefore establish a court that would strengthen the overall human rights system by building on the gains that had been created by the African Commission, and then also filling in the gaps that had existed, particularly with the aspect of state compliance, the aspect of the nature of the decisions and whether they would be binding or non-binding. And so essentially just strengthen the framework by increasing the prospects of true redress for those who seek redress within the African human rights system. I think something else that Dr. Ino mentioned that was very important to note is that the origins of the court are not recent, that the motivation for the court goes as far back as the law of Lagos in 1961. But maybe the only thing I would add is very essentially, civil society, even at that early stage, was quite a foremost supporter for the establishment of an African court, and actually spoke very actively and tried to influence very actively the establishment of the court. So within that 1961 Law of Lagos conference, you would then find civil society strongly represented. But then as we move to the contemporary stages of developing the protocol, in 1993, you see the International Commission of Jurists stepping forward to try and initiate a draft of the protocol, and then eventually working closely with the Organization of African Unity to kickstart the formal process of developing what we now have as the African Court Protocol. So embedded within the DNA of the African Court Protocol is strong civil society support and strong civil society anticipation. And so therefore one would have hoped that it would also be matched with unfettered access for individuals and non-governmental organizations to be able to utilize the platform. But now let's quickly jump into the aspects of the protocol itself. And within that, as had already been raised in the opening remarks, we see that complementarity between the court and the commission is a very critical pillar of facilitating the strengthening of the African human rights system. And so it's reflected within Article 2 of the protocol, which explicitly says that the court will be an organ to complement and reinforce the functioning of the commission, specifically its protective mandate. Article 6 intimates some of those points of complementarity, where, for example, there may be the possibility of transferring cases to the commission, or even requesting the opinion of the commission on the aspects of admissibility. At Article 8, again, it calls for the rules of procedure to be very cognizant of the aspect of complementarity, and Dr. Ino has given us very up-to-date information in his remarks about the concrete measures that are being taken to realize that aspect of complementarity. And then at Article 30, in terms of strengthening the human rights system, the protocol is very explicit about the requirement of states to comply with the judicial decisions that emanate from the courts as a source of reinforcement. But then now we have to deal with the dilemma of access to the court. And so Article 5 governs the aspect of access, and it grants audience to the commission, to state parties, African intergovernmental organizations. But then, as we know, the direct access for individuals and NGOs applies only if declarations are made under Article 34.6. But where are we in practical terms? We then see that 30 out of 55 member states have ratified the protocol, but then only 6 have made the declaration as it stands. And that the worrying aspect is, in fact, there are some states that had previously made the declaration, but have since walked back from those declarations. And at the heart of it is this debate, or a return of the debate on eroding state sovereignty. So we recall within the process of developing the charter and eventually the commission and the court, there was some of this debate about what it would mean to have a regional adjudicator and how that would play against state sovereignty. And you can see from some of the actions of the states that withdrew their declarations, a reemergence of this debate. So very quickly, like Cote d'Ivoire's withdrawal is linked to the grievance they had based on a court decision that reversed a domestic judgment with respect to an opposition politician. A similar trend again was seen in Benin, where the grievance again pertained the quashing of a domestic court decision with regards to someone again in politics. Then in Tanzania, the withdrawal was in close proximity with the decision of the court requiring it to expunge the death penalty from its penal code. And then Rwanda took issue with the fact that a lot of people that it considered to be convicted genocide fugitives were gaining hearing and an audience before the African court. But then the question becomes, how can these states which have ratified the protocol and made declarations under Article 34.6 accuse the court of exceeding its mandate when the court is simply issuing decisions on the basis of its interpretation of the African Charter and related human rights instruments? One aspect of viewing this is that the court is just experiencing political backlash as states want to limit its jurisdiction because of decisions that they don't agree with. On the other hand, it's been talked about that maybe there's some structural inconsistencies within the court that have created a cost-benefit imbalance for states, where they, decry the fact that there's no avenue for appeal, there's a very restrictive review mechanism, and very weak functional institutional shields from the viewpoint of some of these states. The immediate impact is that this limits the access for individuals and NGOs to access the African court. And that the only way that can dramatically improve is if there is now considerable advocacy and diplomacy to encourage states to revisit their standpoints, to reflect on the original vision of the court and the protocol, and therefore maybe increase the prospects for more ratifications and more declarations made. But in the interim, what we are left with is to look to maybe other potential avenues of access to the court. And it's within this prism that the complementarity between the commission and the court becomes important, and therefore the referral procedure of the commission to the court. And it's at this stage that I can hand over to Japhet to take us through the evolution of the referral process and some of our concluding viewpoints. Thank you.
Thank you, Andrew. I'll pick from where Andrew has left. And the question is, begin my discussion on the question of referral of cases as offered as an avenue for individuals and NGOs to access the court indirectly through the African Commission. The question of access to individuals and NGOs, as today, part of this discussion really is to also honor Christof Heyns, is to remember that in thinking about the indirect access for individuals and access to the court, this is what Professor Christof Heyns had to say in the 2001 article that forms the background of this conference today. He said that requiring individuals first to present their case to the commission before approaching the court cushions the blow and has a higher chance of being accepted by states. And it's indeed in this context that Robert Eno also said that it was originally thought that the African Commission on Human and People's Rights would be the main avenue, the main route for individuals and for individuals and NGOs and other actors to access the African Court on Human and People's Rights. But since the inception of the African Court and the two institutions operating side by side, we've had only 3 cases that have been referred by the African Commission to the African Court. And we have seen that during this period, the 3 cases referred by the Commission to the court represents only 1% of cases that have been received by the African Court. The majority of the cases received by the court has been through individuals through the direct access offered by countries that have made the Article 34.6 declaration. And the court in this regard has received 299 cases up to June 2021 this year, representing 92% of the cases. And then 21 cases from NGOs representing 7%. So the question then is, why has it been the paucity of cases being referred from the Commission to the court? And in this regard, there are already scholars and authors who are actually participating in this particular conference that have written and reflected on these questions. Annika Rudman, who will be speaking after us, wrote about this question in 2016. Then Franz Biegon in 2018, speaking and writing about the same issue. The question then is, having this question been treated already in literature, why is it important and relevant to come back to it in this particular conference and at this particular point in time? There are 2 main reasons. The first is that last year, both the court and the commission revised their rules of procedure. And those new rules of procedure now provide a new understanding in the institutions on the question of referral and new policy positions and try to chart a new practice. So it is important to reflect on this question in light of these new rules of procedure adopted by the commission and the court. The second issue is that in the last few years, an increasing number of complainants approaching the African Commission have been requesting the Commission to refer their cases to the African Court. And almost in each case, those requests have been denied by the African Commission. Indeed, one complainant took the disparate measure of proceeding to the African Court and filing a case there, seeking that the court compels the African Commission to refer his case to the court. This is the case of Femi Falana and versus the African Commission. Of course, the case was rejected and thrown out. One, because the African Commission is not a party to the African Court Protocol, but perhaps even more importantly, because the court cannot compel and direct how the Commission executes its mandate. So it's these 2 important factors that brings us to the discussion on the referral. And I now want to proceed onto the question of how the referral mechanism has evolved over time since 2010 to now, because in the 2010 rules of procedure and the 2020 rules of procedure, there are now different treatment on the question of referring cases to the African Court from the Commission. Under the 2010 rules of procedure, there were 2 broad outlines or 2 broad principles that defined the referral process. And this was that a referral will be triggered either by non-compliance by the respondent state and or the second, by the African Commission's discretion based on the principle of necessity. And there were 4 different scenarios, routes that the African Commission had envisaged would lead to cases being referred to the court. The first, under Rule 118.1, was in the instance where a state was not complying, had refused, ignored, neglected to comply with the merit decision of the respondent state. This is the same procedure that obtains under the Inter-American Human Rights System, where cases of non-compliance are then referred to the Inter-American Court on Human Inter-American Court on Human Rights. Rule 118 has never been invoked by the African, was never invoked by the African Commission in relation to non-compliance with merit decision. Although there have been cases that actors and scholars like France had thought that could have been referred. For instance, the Endorois decision that the Kenyan government had shown a negligence and had shown consistently over a long period of time a lack of complying with the recommendations of the African Commission. Then the second avenue was under Rule 118.2 that dealt with non-compliance with provisional measures by the respondent state. The African Commission referred 2 cases on this basis, Rule 118.2. And in the first case of Saif al-Islam Gaddafi against Libya, and the Ogiek case against the Kenyan government.
Japhet, Dr. Biegon, just to indicate on time, please.
How many minutes do I still have?
Your time is up, so the sooner you could wrap up.
Okay.
The 15 minutes is up, yes.
Okay, so please kindly give me about 5 or so minutes. I'll try to wrap it up. Then there was the third avenue on referring cases in situations constituting serious or massive violations of human rights in reference to under Article 58 of the African Charter. The African Court has not the African Commission has not explicitly referred a case on this issue, although the Ogiek case mentioned also Rule 118.3. Then finally, Rule 118.4 that dealt with referral of a case at any stage of the examination of a communication. So this was an umbrella provision that allowed the Commission at any stage of its communications procedure to refer cases to the African Court. And it could be presumed that the Libya case that dealt with the violations of human rights in the Benghazi region was referred under Rule 118. So the question is, why has there been a paucity of referred cases? There are several reasons, and the most one of those that has been often cited is the apprehension by the African Commission, especially on Rule 118.1, that the court would open up a case on the merits and determine it de novo, and perhaps lead to conflicting decision that will not only undermine the complementarity and the profile of the African Commission, but also embarrass the African Commission in that respect. And this was just an apprehension, but in the current new rules of provision of the rules of the court actually in Rule 35.6 says that it has the mandate, the discretion to review the decisions of the Commission. So this was one of the reasons that led to hesitancy, reluctance to refer cases on the merits to the court. Then, of course, there were few decisions on merits decided by the African Commission, and therefore they could not be referred on the basis of Rule 118.1, but also difficulties in following up and determining the status of compliance. Then thirdly, the ability of the Commission to investigate and gather evidence that would lead to reasonable prospects of success when litigated before the African Court. And this reason is particularly shown in the Libya case, the Benghazi case, where the African Commission was unable really to conduct investigations, to work together with the complainants, the original complainants, and be able to prosecute the case to its logical conclusion before the court. In the end, the case was struck out for lack of diligent prosecution. Then, of course, there's been capacity constraints, both human and financial, in terms of the capacity of the court to litigate, have lawyers or have its members, staff participate in the cases in Arusha, has been constraining, and therefore we have also to keep in mind of the broad mandate of the African Commission, including a promotional mandate. There's therefore been quite constraining for the African Commission to prosecute the cases before the court. Then, of course, the complexities of a commission being a sui generis applicant. We call it the commission a sui generis applicant because it's not like the usual applicant before the court, like individuals or NGOs. The African Commission is also an adjudicator of human rights violations, and therefore is submitting cases to the court, turns it from adjudicator to complainant, but also it relies and is dependent on the original complainant for information and other details to prosecute the case. Then finally has been the question of non-compliance with court judgments. because you remember, as Andrew has said, the vision was to have a court that will issue binding judgments, and the court indeed has been doing so. But the non-compliance that the commission has been facing has also then been transferred to the court. And the commission had this specific challenge in the Al-Sam Gaddafi case, where the Libyan government refused to comply with the court orders. And actually the court had to make a report to the African Union Assembly. So the question then comes to, in these challenges may have influenced the African Commission to develop or reduce the instances and routes through which it could refer cases to the African Court. And therefore, under the 2020 Rules of Procedure, Rule 130 only envisaged a single instance where the African Commission could refer cases to the court. And this is where the Commission has not yet decided the admissibility of a communication. Before deciding the admissibility of a case, then it may refer that case to the African Court. This entirely then removes the questions of compliance from the referral framework and puts it entirely on the discretion of the Commission and and before the admissibility question. In terms of implications, this raises the question whether the Commission cannot even look into the communication and see whether there is prima facie evidence of admissibility, for instance, on the question of exhaustion of local remedies. And the role of the original complainant becomes quite heightened, because then there are important factual issues that will come into play during the proceedings before the court. And therefore, this brings important questions about the role and clarity of the place of the original complainant. How then do we enhance the prospect of the referral framework to ensure that we have
Dr. Biegon, I would invite you to wind up, please.
Yes, this is the final. I will end with this slide, Sipala. First is to have clearly defined and justified criteria for referral. And here maybe we may borrow from Article 44 of the Inter-American Commission on Human Rights Rules of Procedure that provides a list of some of the criteria, some of the guidelines that guides the Commission in referring cases to the court in the Inter-American system. Then secondly is to have clearly defined role of the original complainant in the court proceedings. Joint legal teams, for instance, to formulate case strategy, prepare pleadings, decision-making, to assist the court, the Commission in litigating and prosecuting the cases or communications before the court. Then perhaps a more radical approach going forward is that the Commission should adopt a presumption of referral of all communications filed against parties to the African Court Protocol. So essentially, all the 31 members of if cases filed before the Commission are filed against the 31 members of the African Court Protocol, the Commission should think perhaps going forward of forwarding these cases directly to the African Court. Of course, there is arguments that may arise that this may then be circumventing Article 34.6 and turning and rendering in the end perhaps redundant the protective mandate of the African Commission. But we must remember that Decision 1015, for instance, is already trying to think of such a kind of review. Then finally, perhaps it may be important to revert to avenues under Rule 118 of the 2010 Rules of Procedure and trying to address the concerns that led to the dropping of those scenarios under Rule 118 by approaching the question of referral to what Professor Franz, for instance, refers to as purposive and cooperative complementarity, where the court, for instance, would not be looking into questions of admissibility or into every detail of questions that were risen before the African Commission. In conclusion, Sipala, I think the referral system is a partial source of respect to the state backlash. In the end, ultimately, universal ratification and deposition of Article 34.6 declaration remains important. Then there is a need, of course, to unpack the principle of complementarity to see how it works out in practice and sustain engagement between the court and the Commission to tease out practical aspects of complementarity. And then finally, there is a need for defined framework for engagement between the Commission and the original complainant in relation to referred cases. Thank you, Sipala and the moderator.
Thank you, Andrew Songa and Dr. Japhet Biegon, for your excellent presentation. This second paper weaves quite beautifully from the first, discussing questions of systemic interaction of the institutions within the African human rights system, in particular the complementarity. Fun fact, it took 10 years for the Inter-American system to begin its complementarity system, and individuals have no access to the Inter-American Court. And between 1978 and 1988, before Velasquez Rodriguez and Gordina Cruz were first filed, there was a similar situation as what we are facing. And so maybe again, the reflections of our two panelists today point to a future where the complementarity makes the system work more effectively.